morning to all our viewers, listeners, and panelists. My name is Jacqueline Brodsky, and I'm a Deputy Director of Prosecutor, stationed here at the Office of the Director of Public Prosecutions in Johannesburg. This morning with me on the panel is Advocate Hanetsani Tsusa, a senior maintenance prosecutor from the Sexual Offences and Community Affairs Unit. And next to her is Mr. Melindeli Dingai, Maintenance Officer from the Department of Justice. A warm welcome to you. Now,
Thank
today we
you.
are having a discussion on maintenance, and we are going to specifically speak about Chapter 5. Now, Chapter 5 deals with the enforcement of maintenance orders. After this discussion, we will then have a question and answer session. So, without further ado, let me proceed with asking the first question to the
Thank you.
panelists. My first question is, I have a court order that directs the father of my child to pay R1,000 maintenance per month into my bank account. The school fees to be paid monthly and directly into the school's account, and further to purchase clothing to the value of 2,000 rand every twice a year. Now, he is not paying for maintenance. What can I do, or what should I do to enforce this maintenance order?
Good morning, and thank you very much for the opportunity. When you have a maintenance court order and the respondent is not paying or complying with the order, you need to go back to the court where the order was granted. And then you apply for enforcement, as you mentioned it. And then in enforcement, we have a forms which the clerk of the maintenance court are going to assist you to complete the forms. And then with the forms, you need to bring some supporting documents to prove that the respondent is not complying with the court order. One of the documents you have to bring is the copy of the court order, which we normally don't ask you to bring because the file is already in the court, so the order is there. Unless your order was made by the High Court, maybe upon divorce, and you are appearing at the maintenance court for the first time, then we'll need a certified copy of the court order when you come to apply. But if your file is there in court and the order was granted by the magistrate's court, you just go there, complete the forms, which the clerks of the court are going to assist you to complete, and then commission. And then some documents which we'll need to bring is the proof that he has not paid the R1,000 maintenance. Currently, we're doing direct payments. So normally the payment should be in your bank account. So we need the bank statements for the period that he has failed to pay. You can just add 1 month so that we can see the reference how the maintenance was being, how was it reflected in your bank statements. Then you bring the period, even if it's 5 years, you have to bring the bank statements for 5 years period. If it's 3 months, bank statement for that 3 months period. And then with regards to school fees, the order says you must pay directly to the school. So it will mean you need to bring the statement from the school to show that the fees are in arrears. And then with regards to clothing, if the order says he needs to buy the clothing to the value of 2,000 rand and he did not buy, then it means that one you're not going to have much proof, but then that's when we'll talk about an affidavit, which you're going to complete a statement under oath to say the order says he needs to pay 2,000 or buy 2,000 rand worth of clothing twice a year and he hasn't bought for this period. So I'm claiming that 2,000 rand back. And then when you have your documents with the form, the other thing we need is normally the breakdown of the arrears, because we need to see how much is for the 1,000 rand maintenance, how much is for the school fees, and then how much is for the clothing. Because when you check at the form, it just got one space where you just put the total arrears. For to make it easier for the court to process your application, you then do what we call a breakdown of arrears. Other call it a schedule of arrears, whatever you may do it. So you put down maintenance, clothing, and school fees so that we can see what is there. So with your affidavit, you can add some more information which might be necessary. Remember, with the attachment, we can do different processes. So affidavit can assist us to know exactly whether the person is still employed or the person is self-employed or he has left the employment. So that information, if you have it, you have to put it in an affidavit form, especially in a case where the order was made years back. And after those period, there are so many changes, maybe change in employment, whatever we have in the court file is changed, no longer the same addresses and all these things. So those information can be added in an affidavit. And then, as I said, the certified copy of the court order from the High Court, if you are, or from the regional court, if you are, your maintenance was made during your divorce proceedings. Thank you very much.
Thank you. That brings me to my second question to the panelists. Um, I've got all these necessary documents now together with my affidavit, and it's now with the clerk of a maintenance court. What will now then be the procedure that will follow to have this maintenance order in force and to gather all the arrears?
Good morning. My name is Mlinde Ndingaye. I'm the maintenance officer from the Department of Justice. The first thing that we need to talk about is the position where you will find that there is an enforcement of a maintenance order. The enforcement deals with, we have, the first one will be a warrant of execution. The warrant of execution deals with the immovable properties or movable. You start with movable, then we will be saying that it will be in terms of section 26, read with section 27 of the Maintenance Act 99 of 1998. And they will find that the order in terms of section 27 will be done in terms of section 27 subsection 1. And therefore, we will be proceeding with that particular application. Now, the person has to complete a J306E, which is the application form, and also the court order will be attached, and also we will be dealing with the founding affidavit on which your application is based. And then you will be also be doing the bank statements, and not one thing that will follow also, it will be breakdown of your arrears. Then the court order will be made. Once the court order is made, it will be made in terms of section 27, subsection 1. That particular order, the maintenance clerk will assist you to complete the form that will be attached to the order. And you have that particular position as the one that you are complaining. Then it will be sent to the sheriff. Then all other things that will follow, it will not be with us as the court. It will be you dealing with that proportionately, and then whatever that will be the sheriff will take, then the storage it will be upon you. That's where we end up doing for yourself. And the second one, it will be the attachment of emolument. If the respondent is employed and therefore is earning a wages or a salary, then the attachment of emolument. So I'm going to attach your salary, the amount of the arrears, plus the monthly maintenance, because you always attach the amount plus the arrears, because the maintenance amount must be paid correctly, and also you must also be paying the arrears up until those particular arrears are paid in full. Then you will be doing the attachment of emoluments in terms of section 28, subsection 1. And that particular part, remember, it's done ex parte. It doesn't mean that the respondent must be before the court when this particular application is done. And if it is done, it will be done in the same fashion as stated in section 27.1. That means your J306E will be completed, and then you will be going down to 8, because In the first one, it was A, which is our warrant of execution. B is the attachment of emoluments in terms of section 28. And then we will be saying section 28, subsection 1, the order that will be granted. It will be the same because once you finish that particular form, the order must be attached, the founding affidavit, the bank statements, and also the breakdown of arrears, and the order will be made. And that will be attached in terms of section 28.1. It will send directly to the employer. There will be a notice to the employer in terms of section 29, subsection 1, which will be this particular order must be deducted directly from the salary of the respondent. And therefore, that particular employer must be able to return to the court to say the feasibility of implementing this particular order will be giving rise to say this particular gentleman cannot be able to pay this amount based on this particular amount that he is earning as a salary. But that particular one, if the employer doesn't come to us and say this particular amount I'm unable to implement because of it, then now there will be an application in terms of section 28.2, doing amendment, suspension, or a rescission of that particular amendment, of that particular order that was done in terms of section 28.1, to amend it to make sure that there will be feasibility of implementing the order. And the third one would be C, which is attachment of debt. That particular one, it will be telling you that this particular person left employment, he was retrenched, or he has resigned. Once he has resigned, if there was a garnish order in terms of section 28.1, it is the duty of the employer to, in fact, to inform the maintenance court to say, this particular person is no longer employed. Your last payment to the beneficiary would be this particular month. And then this particular month, then they have to tell us this particular person has left employment, has been retrenched, or he has resigned. Once he has resigned, then we will do an interdict, interdicting that particular provident fund or administrator of a provident fund or retirement annuity or a pension fund, that they must not pay that particular amount until we have entertained the question of arrears and also entertain the question of future maintenance. Future maintenance is not automatically say that that particular person was not complying with the order. But if we find that there was a conduct of non-compliance with the maintenance order, it is upon the maintenance court to say, let us do a rule nisi interdicting that particular provident fund or pension fund or provident fund or retirement annuity, not to give the benefits to the respondent up until we have recovered the arrears and also the future maintenance for the child, because we don't know when this particular person is going. That will depend on qualification, it will depend on the person. How old is this person? And therefore, we will require to make sure that at the end of the day, there must be money that will be kept in abeyance up until the gets the amount that is due to that particular child. And also remember, whatever that we're doing in terms of section 28, subsection 2 of the Constitution of the Republic of South Africa. That is where we are saying the best interests of the child are of paramount importance. Whenever there is particular part, we're dealing with the future maintenance. Also, some of the things that will be discussed, it will be saying, in the meantime that we are unemployed, there must be something that we are doing in order to make sure that the best interests of the child are taken care of. That is the duty and obligation of the parents in terms of Section 15 of the Maintenance Act. Thank you.
Thank you, Mr. Guy. Sure. So what I can gather from your explanation is you talked about future maintenance. So this whole process of enforcement of maintenance order can also be used for future maintenance and not just for the maintenance order as it was given a few years back.
Thank you. It is important that we are looking to the future of the child. And therefore, it is also important that we understand where the parent that was paying maintenance, who was supposed to pay maintenance, and now, if now he is reneging from that particular obligation, and therefore it is upon this particular court to deal with this particular matter to make sure that the best interests of the child are taken care of. It is also important that we look into your age as the respondent that is paying maintenance and also look into the beneficiary. How old is this child? If the child is still a minor and therefore we are not doing what is basic necessary and you are reneging from your obligation, it is upon the maintenance court to make sure that you are doing your obligation to the best of your ability. And also what we are looking at is not, we are not fighting you. We are making sure that we are willingly doing what is basic necessary for your child. So that that particular child, remember, the maintenance is a reciprocal duty. It goes from parent to the child. So even if that particular parent is no longer working, it means that that particular child, if he's employed, he can be able to maintain the parent that was maintaining him whilst he was still growing up. So remember that that particular, it goes from the parent to the parent up until the grandparent, maternal and paternal. We are not, in fact, discriminating because remember there was a case that was in 1927 of Mutan versus Joseph. That's where they're saying only the maternal grandparents will be able to maintain the child. But now it's no longer the case in our present constitution. It says that we cannot discriminate. It must be both maternal and paternal. Therefore, it is the duty, even the grandparents are responsible. They are responsible if both the mother and the father are unable to maintain their child. So that's where you'll find you end up going to maternal and paternal grandparents. Thank you.
Thank you, Mr. Gungai. Thank you for that insightful explanation of Chapter 5. Now we're going over to questions and answer sessions.
There's nothing. Okay. If there are no questions, maybe I can just
Yes.
add on future maintenance.
Yes.
Future maintenance is when we look at the court order in order to secure the future payments of the maintenance from this parent who is paying maintenance. For example, I'm working, I've got a court order today. It happens that I get retrenched. And then with my retrenchment, I'm not at that position, I'm not having any other employment. So it means I'm being retrenched, then I'm gonna sit at home, maybe then start to apply for employment. So that's when then we have to check as the cost to check whether can I still continue paying my maintenance even after retrenchment. If maybe there is a little, doubt that no, we cannot certainly say the maintenance are going to, the payments are going to continue, based of course on different factors, then the applicant or the person who's staying with my child can then come to court and apply for my retrenchment package, whether it's pension or whatever, then to be attached so that the court secures the future payments of this child's maintenance. So if I leave my employment because I'm resigning because I'm going to get another employment, then we may not look at future maintenance because chances of me continue paying maintenance is there because I'll still be employed. So it's normally when we see that this respondent is not going to get an employment. And of course, with cash being in your account, anything can happen. People are squandering millions in few months' time. So that's when we'll say, but then the child is still young, the child still needs this and this and this. So let's try to have a future maintenance court order. Then, of course, the application can be made and the court will look into the application and grant a certain lump sum of payment, which is either going to be paid into the guardian's fund or it's going to be paid into the court's account, so that we can then continue to pay the monthly court order to for the child. Remember, future maintenance is not a payment which is going to be paid into the parent's account. So it's going to be kept safe so that the child can then continue to receive the monthly payment in terms of the court order. Thank you.
Thank you, Advocate Susa. We've received a question, and it asks, the question is, can a parent or a grandparent apply for maintenance from a court? And that's the first question. And the next question is there an age limit for the child in terms of future maintenance until the child is 18 years or 21 years of age?
Okay, let me maybe address the first one. My colleague will then tackle the second one of age. Okay, he mentioned about grandparents applying maintenance or paying maintenance. This is what the law says. The law says maintenance is a reciprocal duty between certain people who are related. So basically, on main cases, we have a parent and a child. Then because it's a reciprocal duty, it means can also start from a child to the parent. So when I'm paying maintenance for my children, one day, not necessarily maintenance, even supporting them, like taking care of my children as a parent without a court order. I don't have to have a court order for me to be able to apply maintenance from them in future. Currently, I'm supporting my kids, they're growing up. It happens that when I grow up, I can no longer take care of myself. Then my children have got the responsibility legally to maintain me. And if they don't do that, I can go to court and apply that. Now I've got my child, he's working and he can maintain me, but I am not in a position to maintain myself. Of course, I'll give the reasons why. And then the court will look at having a court order against my child to maintain me. Now, myself again, as the mother of this child, and then he's got a child, so I've got a grandchild. When my child cannot maintain his child or her child, I have a duty legally to maintain my grandchildren. Then it means even when things turn over or opposite, in future you find that now I cannot maintain myself, my grandchildren are doing well, then I can also apply maintenance for my grandchildren. That is how it works. So yes, maintenance between parents, and if one can add, also adopted children. Adopted children also are regarded as children in terms of the law, because legally when you adopt somebody, you have a legal duty or to maintain that person. You take full responsibility and rights. So that one applies to also legal children, legally adopted children. So yes, grandparents can apply for maintenance.
Thank you.
Maybe another thing, sorry, colleague, just to add, I don't know whether the question is about grandparents applying for themselves or applying for the grandchildren. Normally, we have the situation where you find that I'm working in Johannesburg. I left my kids somewhere with my mother, but then I'm returned to support my children. My mother has the right to go to the court where she's staying and apply maintenance against me as the parent of the children. And she will go and say, you know what, I'm looking after her children. She's not maintaining the children. I need maintenance. And the court is going to do the application and the matter will then be looked at. And also the grandparents have got the right to apply for maintenance against the father of the same children if they are not supporting. So a grandparent can go to court and apply for maintenance against both the mother and the father for the children she's taking care of. Thank you.
Thank you.
Thank you. One thing that we will be dealing with is the age. Remember, you have that particular responsibility of maintaining a child. You must maintain that particular child until that child is self-supporting. Even if the child is working and that particular amount that he is earning or she is earning, that particular amount is not enough to cover the child's expenses. It means that you are responsible to assist that particular child. But one thing for sure, you must be able to state the needs, because whatever the court will consider, it will consider the needs of the child, which are necessary for that particular child's upkeep. Even if you are 25 years old and then we find that you are unable to look after yourself, it is within the court's jurisdiction to be able to see the needs of that particular child, and also that particular child must state all the necessary needs, and also you must be able to prove. Remember, in a maintenance case, it's not an amount that you are talking about. It will be the needs versus what your upkeep will be. And it must be necessary for you to show the court it is necessary for me to get this particular maintenance up until I'm able to look after myself. Therefore, it is not about the age, but it's also about how best can you help the child. The needs versus the means. That is what is basically necessary when it comes to the age that we're talking about. You must be able to show the court, and that particular court must be able to, to see that indeed you do have the need, and therefore there are means to meet that particular need. Thank you.
Thank you. So, if I understand you correctly, Mr. Zingard, even we children at this school, through the university, and start their first job, and the salaries we know starting out is not enough to cover all their expenses. So that child can then approach the maintenance court to go and show its needs, and then if it proves it, then the court will grant that maintenance order against the parents to maintain the child's needs.
Thank you. It is very much important that you are able to show the court that there is a need. If there is no need, then we cannot be entertaining that particular. Remember, whatever the court order will be made, even if you make an order, the court will be inclined not to make an order in terms of 1661C, where they see that there is no need for this particular court to make any order. But we must be able to satisfy the court that there is a need and the parent has the means to meet those particular needs. It is very much crucial for that particular child or an adult, even if you are an adult, you must able to show this particular court, this is the need that and it is necessary for me to live and have this particular upkeep. And if there is no need, then the court will be inclined not to make any order.
Thank you. Thank you for that clarity. Then we've got, then we've got another question. What are the consequences for the employer if I fail to comply with a maintenance order and deduct the specified amount from the respondent's salary? Then there's, if you all the questions.
Oh. It is quite important for the employer to comply with a maintenance order. I'll make an example. I had a recent case that was in Kagiso Magistrate Court, where you'll find that the employer has failed to comply with the maintenance order. You have a section 29, subsection 4 of the Maintenance Act, which says the employer will be held liable to pay for the respondent that is not complying. If the employer is not implementing, then that particular section is saying that the employer will be held to be paying that particular amount for the respondent because they have failed to implement. Once they have failed that, therefore, it's upon that particular person to come and say the employer is not complying. Once it's not complying, so you invoke section 29, subsection 4, and then you come back to court, and therefore the court will be inclined to make an order against the employer, not against the respondent. The employer will be held as the first respondent, and then the respondent will be the second respondent upon making sure that that particular order is implemented.
Thank you, Mr. Dengai. Then the next question is, if a respondent is a director of a company and a close corporation, does the income he derives from those two posts, can that income be included in his normal income he receives from his day-to-day job?
Thank you. This is one of the challenging situations when we have to enforce the court order. Court orders are easily enforceable when you have a third party who is not party to these two. Sorry, I don't know if they heard me. I was saying, I'll just have to repeat, maybe I was not clear enough. I was saying this is one of the challenging scenarios in a maintenance matter, because what we were talking about previously was when there is an employer, which is easier because it's a third person. That person is not involved in this maintenance. The involvement is only because there's a contact between the employer and our respondent. Now, when we have our respondent, who is a director of a company and a close corporation, and it derives income, sometimes it doesn't. I'm telling you, people, it's not an easy case to just say straightforward, you can do this. But with regard to income, all the income will be regarded. Remember, when we talk about maintenance, the means, as he mentioned it, means it's not only referring to the salary or the income which you derive from a company. It can be whatever you have around. If you've got properties, it's also the means. If you've got more investments, they are also the means. So then we look at the means. So everything is considered when we do look at the possibility or the means which a person does have, so that we can determine the amount of maintenance. So yes, but enforcement thereof, you find that it's very, very difficult, because when I'm the director of the company, I'm the respondent, I'm also the employer. So when you send the order to me as the employer is just as sending to the respondent. So the fact that I disregarded the order which was made in court in my presence, I don't see any reason why I will regard and look at the enforcement order as important. But anyway, that's when, if the respondent is the director of the company, that's when we go to criminal prosecution. The income, all income is regarded as the means.
Fund or pension that can be set aside for the future maintenance of a child, and how would this amount be calculated or determined?
I'm gonna take it.
Okay. Thank you. It is quite important that we are looking at the age of the child, firstly. And also, we are looking at the age of the respondent, and also, is this particular person going to be employable in the near future? Whatever that we will look at, we look at the age of the child, and also look at the means available in that particular provident fund. It cannot be a situation where we say we're going to take all the money, but we are making sure that a certain age, maybe if I give you 5 years now, then I will be counting that this particular child in the next 5 years, they will be 13 years old. Now the child is 8 years. But we need to look into the feasibility of having that particular amount of money. But the money will be kept in the court account, because we cannot give a lump sum to the beneficiary. Because some of the people, they will get 120,000 today. Tomorrow, that particular 127,000 is finished. And once it's finished, what are the best interests of the child? And also what we're looking at, where I'm going to make sure that that particular money will be disseminated to you as of the court order. Because remember, that particular court order doesn't diminish just because you no longer employed. But that particular court order will be saying there is an amount that is kept in the court account, and that particular amount will be disseminated as it was as per the court order. Until such time that the respondent apply for a discharge of those particular maintenance obligation. The question is, those particular obligation pertaining to maintenance, are they going out just because you're no longer employed? That is why I'm saying we're going to be looking at your age and also looking at your employment and see if you are this particular person, and therefore are you employed? Are you, in terms of the age that you are, then in terms of the qualifications also, then you'll find that maybe a person is an electrical engineer, and then he can go and open a company of himself. And then once you look into those particular situations, then you are able to say, look, you can be employable, you cannot maybe stay a long time unemployed. Therefore, we are looking at those particular situations and making a decision. But that particular decision is not going to be made by me. It's going to be made by court, considering the facts that are put before the court, so that the court can consider and make sure that that particular person is able to make sure that the maintenance obligation doesn't diminish because he's unemployed. Thank you.
Thank you. Then there is, let's wrap this up, and this will be our last question that we will take. And this question is, when will the online application system go live?
Thank you very much. The online system, in terms of the application, has been opened by Department of Justice. As much as I will remember, even last year, we will find that you will receive through ICMS an application coming from the complainant. It needs to be done and be, in fact, finalized, and therefore you will be given a date where you will be, the directive is going to be sent to the respondent, and then the respondent will know of the court date. It depends if we send it via SMS or we send it via email. As long as we have those particular things that says this particular person's address, this particular email address, it belongs to the respondent. It has been happening, but most of the people, they are not utilizing it, but they must, because it will be helping them going to court, skipping work, and therefore it is quite important. Also, what we must look at in terms of the amendment that we are having of 2015, it says you can go and open an application where you're working, where you are having a business, and also where you are residing. Thank you.
Thank you, Mr. Guy. Now, just to wrap up and in closing, could you kindly share the information to our viewers and listeners on where can they get any assistance if they have any maintenance issues? Where can they go? Can they
Jurisdiction.
find it?
Okay. Maintenance courts are in every magistrate's court. In terms of the law, each and every magistrate's court is a maintenance court. Of course, except the branch courts where you find that maintenance is not done fully or they do it in few days. But otherwise, your nearest magistrate's court, that's where you can get your maintenance court inside. So now, Mr. Ndingaye mentioned the places where you can make the application. We normally call it jurisdiction. So if I go today to a court, they can just say, no, we don't have jurisdiction. Simply, they're saying you cannot come here. So now, in terms of the current, in terms of the Amendment Act, it extended or added another jurisdiction in order to cover many applicants because there were challenges. So now, if I'm staying in Johannesburg, area. Johannesburg, I mean Johannesburg CBD, because Johannesburg is huge. Then my maintenance court is Johannesburg Magistrates Court in Fox Street. If I live in Honeydew, then the maintenance court which I can go to is Rodeport. If I have a business in Pretoria where I'm running, whether or I'm not fully employed or whatever, then I can go to where my business is. So in other words, you can go where you are employed, nearest magistrates court of where you are employed, the nearest court of where you are residing, or the nearest court of where you are running a business. So sometimes we have situations where the applicants or the mothers or the parent is not living with the child, like on an example which I gave previously when I left my children with my mother. The law says I can also apply myself as the mother of the children from the area where my children are residing. So in other words, if I feel like it's fine, I don't want my mother to keep on going to court and pulling my boyfriend or my husband, then I can say I'll do it myself. But of course, then it will be an extra expense for my traveling and stuff if I'm working far from where I'm staying. But otherwise, the court where the children are residing has got jurisdiction to do the maintenance application. So if you have a court order, like I said before, court order from the divorce court, and you've never been to a magistrate's court, maybe you use the high court. So you can go to any of those courts which I mentioned, where you're residing, where you're employed, or where you are running a business, or where your kids are residing, with your certified copy of the order is recognized. Then you just go there and open the file, and the process will then proceed. Either you want increase or whatever, or decrease, you can do it from your high court order. Thank you.
Thank you. Now that concludes our session on this webinar on maintenance, and I want to thank my gratitude to the panelists for their valuable contribution, and I think this was a very informative session and a very helpful session for our viewers and listeners out there.
Thank you. Thank you very much.
Thank you very much.
Thank you. You guys are ropana. It's not even an hour.